though people feel that it is something bit for lawyers and judges, but judges' appointment, I think, as has pointed out by Mr. Kashyap, is very relevant for the people of this country. It's very relevant for the working of the Constitution itself. When Mr. Khaitan was telling that the system of appointment which changed, from 1994, it was S.P. Gupta 2, the judgment which is normally referred, Mr. Vishwadas, my old friend, and which brought the changes. Prior to, it was simple what was written in the Constitution, that the name of the judge would be recommended by the Chief Justice of that court. And that name will be sent, which will go to the Ministry of Justice, ultimately to the Prime Minister, and then President issues warrant. That was a consultation. Government had the right to say, well, please supply some more input about this recommendation, Mr. Chief Justice, which you have sent the names. And as just said by, I think Mr. Srivastava mentioned about, a very cordial relationship existed. The Chief Justice was, this is no question of, he is my man, therefore he has to be appointed. How the things have changed. If there is a legitimate objection to any name, the Chief Justice would reconsider or will get more inputs and again send to the Ministry of Justice. Please, I have checked it up. No problem. Go ahead. The government says, okay, reappoint him. Because that was in consonance with the spirit of the debate of the Constituent Assembly on the draft Constitution. This is how the system worked from 1950 to 1992. I was telling Suman that I am a product of a system which was as per the Constitution, as it is true. 1992, there was no S.P. Gupta. Judge never appointed judges. Judge was appointed with the consultation with the Minister of Justice, Prime Minister, and of course the Chief Justice. That was the domain of and the process of appointment. 94 brought a great change. And I was going through this NEHRU Vision, the magazine which have been published about this seminar. And it has been very rightly said, and I won't miss the word. I am outside, so I am not even bothered of having a notice of contempt issued. Personal caprices of two gentlemen sitting in the apex court brought in 94 S.P. Gupta's case, aided and abetted by so-called jealous of independence of judiciary, who thought that government is appointing their own judges. There will always be aberrations. There may be some people who have been appointed, who may be part of, very close to the government, I am not saying. But not that they are all judges who were appointed during those periods. If that was so, you in the audience, most of you very mature administrators, lawyers, a person working in different field, tell me one name after 1994 which people of India remember. It was all those judges, whether it was Gajendra Gadkar, whether it was Patanjali Shastri, whether it was Krishna Iyer, whether it was P.N. Bhagwati, they were all appointee of pre-1994 amendment. So if now we have so many judges, so many chief justices, they are very powerful. Their lordship, they feel that they are the ultimate when they become the CJI. But is it true? Why we want to say we will keep the power of appointment of judges in our hand? I will give you, because the topic is Collegium and Judicial Autonomy. Though I don't agree with the word autonomy, there is no question of any autonomy. It is in the framework of the Constitution. Every institution has to play its own role. There is nothing like autonomy. I had a very interesting kind of this debate when I was the Chief Justice, Acting Chief Justice of Delhi High Court in 2005. There was a lot of, Mr. Kashyap, you will recall, a lot of press news about the court's usurping power of the executive, and there should be a Lakshman Rekha between the two. And Somnath Chatterjee was the speaker. So some lawyers, people organize a meeting, a seminar in the Parliament, Annexi. So from the legislature, Somnath Chatterjee came and spoke. I was sharing dais with him because I was the another speaker on side of the judiciary. And Somnath Chatterjee, he was a very eloquent lawyer himself. He was look at me, he will say, they have no right to encroach upon parliamentary sovereignty under the Constitution. Parliament is sovereign under the Constitution. Nobody can take the role of Parliament, howsoever important institution, maybe the Supreme Court. Supreme Court has no power to legislate. So I said the same thing over there. You have all power to enact. Nobody can challenge that power. And if somebody says he is a fool, or he doesn't understand the law or the Constitution, power to legislate lies with the legislature. But what you have passed or enacted, that power to interpret that law lies with us. And sometimes maybe we interpret it wrongly, don't get annoyed. Because you have got power again to amend what the court has decided. Sometimes court strikes down some enactment, constitutional amendment. The parliament or the state legislature, they are empowered to enact it again. The only thing which is a grey area now, and Mr. Kashyap, to your understanding, you have been a great person who is dealing with law, legislature, is the basic structure of the Constitution. But where the basic structure of the Constitution has been defined? Nowhere. In no judgment of the Supreme Court, they have touched upon this will offend basic structure. But what is basic structure has not yet come as an authoritative pronouncement of the Supreme Court. We normally talk independence of the judiciary is a basic structure. Well, everybody says so, everybody agrees to it. We say there is a basic structure, that there should be, we are a federal character, federal constitution, by a unitary government, fundamental rights. Nobody can take away fundamental rights. Our one Prime Minister tried to took it away, and she is even being criticized even today. So the question is, when judges have this responsibility to interpret the Constitution, then whether the Collegium system which has been introduced has resulted in making the judicial appointment transparent, based on merit, based on legal acumen, or based on their personal consideration. Now, some people, when I was there, I say, well, he's a very good judge. Why don't you take him? They said, no, no. If we take him at this stage, he will be the Chief Justice for 3 years. Therefore, we have to find out someone who can fit in, take 1 year, we can give him another 1.5 years. Is this the consideration for appointment? You all know there are judges who are not appointed by the Collegium. After 2-3 years, they were again appointed. What kind of system it is? At least mind-boggling. I can't understand. Recent case. 2 recommendations were made, and we read in the newspaper, after considering all the relevant considerations and all the candidates before, we find these 2 gentlemen, Mr. Pradeep Nandarjog and Mr. Justice Vijender Jain, to be fit to be appointed as Supreme Court judges. One judge came, the composition of Collegium changed, and those 2 judges gone. Instead of 2 other names were picked. I have no quarrel with the other 2 names. I may not be supporting the other 2 gentlemen. I am only on the principle and probity and the Collegium's transparency, considerations. Is it for account of one gentleman or second gentleman? A person becomes less meritorious than the others? How can this system can function and inspire confidence among lawyers, among litigants, and others? Because independent judiciary is a buffer in a democracy against mobocracy and chaos. If you do not have an independent judiciary, it is the democracy which will suffer. People's faith will erode because parties driven by their own political agendas and philosophy, they are daggers drawn. They feel others is untouchable. We are the only people who can take India forward. In that scenario, if judiciary plays a role which sees that order prevail in the society, there is something. But if we fail at the top, if we fail in securing appointment of judges in a transparent manner, in a manner where merit takes precedence. Now, you people do not know, but as I am one of the part who had to function in the system after Collegium came in, now the system is a Supreme Court judge is appointed. A Supreme Court judge is appointed, then not only these 5 judges who constitute Collegium, they have said, by their judgment, they have also got the concept of consultee judges. Those consultee judges are those who come from that state. For example, a person who has to be appointed from Punjab and Haryana to Supreme Court. Now the judges from Punjab and Haryana who are already in Supreme Court, they will also be the consultee judges for the appointment of that judges to the Supreme Court. You read Ambedkar, he was a very wise person. This is what he said. And he said about the Chief Justice. that he is also a human being. His personal thinking, prejudices, his feelings about A, B will manifest in his decision-making process. And this is what is happening. If a names come, consulting judge says, he was very bad in our court. He goes. They have been together in that court. Maybe the other guy is senior than this fellow, he came earlier. But if he says, well, it's not good, I heard something about him. So he goes. Is it the system of appointment? Nowhere in the world. Nowhere in the world judges appoint themselves. It's, I don't know when the day will come, we will have a system. There cannot be any way, cannot be foolproof system. The government, the previous government, this government, they both tried to bring in some amendment, constitutional amendment in appointment of judges. But that was again struck down by the Supreme Court. So it's a long fight. It's not going to end because it's very difficult to leave power. You can see just now. Trust vote takes now not one day, it may take 1 week. So many days. So, but they may do it. But judges can't afford to do it. They are like Caesar's wife. And if a finger is raised, that's enough for him. Judges cannot be compared. That's why we cannot be compared with other people. Whether he's in the executive, whether he's the head of the state, or whether anybody. Because a judge has to keep himself above all these considerations. That is why when a person goes after trying to bribe somebody or trying to go to the person, say, Goel साहब हमारा काम करा दो, नहीं होता है, अफसर के पास जाता है, नहीं होता है, then ultimately he goes as a last resort to the court with the hope that ultimately I will get justice. He goes to the place thinking that it's a temple of justice, I must go. And so long that feeling remains, and that is the feeling which is a sustaining factor, the strength of the Indian judiciary. And if that is eroded, it will be the sad day for our democracy. You have organized a very interesting subject, the Collegium and judicial independence of judiciary. They are interwoven. I am a very strong critic of the Collegium system adopted by our Supreme Court after 1994 judgment, but we are all bound. And just to say, Mr. Kashyap, that when you say that Supreme Court what decide is binding on the courts all below. No, I just amend. It is binding on all, irrespective whether they are court or anybody. The civil authority, anybody under Article 142, the Constitution says the order of the Supreme Court, the direction of the Supreme Court shall be binding throughout the territory of India by all civil administration and courts. So it's a very important aspect which you have touched. I hope this dialogue and debate will continue till something meaningful is achieved by these meetings. Thank you very much.